This is LXBN TV, and I'm Colin O'Keefe. Last week, the Supreme Court in FCC v. Fox ruled in favor of the broadcaster, excusing them from paying indecency fines that had been previously levied against them. To explain the case, we bring in Kevin Goldberg, attorney with Fletcher, Hildreth, and author on the firm's CommLawBlog, an excellent publication on the law of communications. Kevin, first off, can you explain the background of the case and what exactly the Supreme Court ruled on?
Yeah, it's pretty detailed. I think the best way to think about it is sort of in three time periods. You have the early period, pre-2002. You have 2002 to about 2004, where a whole lot was happening at the FCC. And then you have the litigation afterwards. So really quickly, this actually goes back, if you really want to think about the issue in depth, to 1975, when George Carlin did his famous 7 Dirty Words monologue on a Pacifica radio station that was available over the air in New York City. And a parent heard it with his son in the car in the middle of the afternoon, didn't like what he heard, and filed a complaint with the FCC. That indecency complaint went all the way to the Supreme Court, and in the famous Pacifica decision, the Supreme Court ruled that, yes, the FCC had the authority to impose an indecency fine against Pacifica Radio. It said its decision had to be construed very narrowly so that stations wouldn't engage in self-censorship and the FCC wouldn't engage in censorship. And for a long time, that's exactly what happened. In fact, through 1987, the Commission construed everything really, really narrowly. Then it did something differently, and it said, we're not going to look at just those 7 dirty words. We're going to look at the full context of a broadcast. But what it did at the same time was say, look, we want repetitive use of those words before we're going to start an indecency enforcement action. And that was true for a while. And then in 2001, they issued some guidelines again. And the guidelines were basically 3-part, what they're going to look at. They're going to look at just sort of how indecent the broadcast, radio or television broadcast was. Whether the indecent, the actionably or arguably indecent material was there to titillate or pander. And most importantly, though, again, whether it would dwell on or whether it was dwelled on or repeated at length. So now you're all the way up to 2001. Pacific is still being construed very narrowly. And the FCC not taking a lot of action against stations. Come 2002, late 2002, you have the famous Billboard Music Awards show with Cher accepting an award with a certain 4-letter word starting with F. I don't know how your viewers are going to want to, want me to say it or not. I prefer to say it, and the Supreme Court dodged the issue. So tell me, should I?
Go ahead, yeah.
She basically said, I've had my critics for the last 40 years telling me that I was on my way out every year. Right, so fuck them. That's what she said, and it wasn't bleeped out. And then about a month later, you have Bono coming forward on the Golden Globe show on a network broadcast, and he's Irish, and you're Irish, and you know how Irish people use that word. It's kind of an adjective. And he says, this is really, really fucking brilliant. This is really great. The FCC takes no action. February 2003, an episode of NYPD Blue has a little bit of nudity. Bare buttocks, the side of a female breast. Primetime television before 10 o'clock, so it was not in what we call the safe harbor, arguably indecent. February 2003, Nicole Richie and Paris Hilton, you may or may not even remember them at this point, again at the Billboard Music Awards, again on a network broadcast, and Nicole says, have you ever tried to get cow shit out of a Prada purse? It's not so fucking simple. And nothing has happened to this point. And then in 2004, all of a sudden, the FCC reverses its earlier decision with regard to Bono, and for the very first time, again, 2004, after all these things have happened, they say that word, the F word as they call it, and as the Supremes called it, but the word fuck is so just above and beyond the pale that it is by itself, standing alone, indecent. And then they go back and start indecency actions against Fox and ABC for these other broadcasts, especially for most of us, the use of the fleeting expletives by Cher and Nicole Richie was the first time one word had gotten people in trouble. That kicks off the litigation. It goes to the Second Circuit Court of Appeals. And while it's there, the FCC says, wait a second, we want to go back and voluntarily remand this so we can give a better context. And they go back to their 2001 indecency guidelines that I mentioned, which again still said, we do not plan to act on just one use of the word. And they give it better context. It goes back up to the Second Circuit, which says, we don't like this. We think the FCC is actually engaged in rulemaking. It did a 180 switch in position, and it did it without any Administrative Procedure Act notice and comment type rulemaking. They acted arbitrarily and capriciously, and they're going to kick out the actions against Fox in this case. This goes up to the Supreme Court. argued on Election Day 2008 at the Supreme Court, focusing on the Administrative Procedure Act issue. The court says, you know what? They didn't need to engage in notice and rulemaking procedures. So at that point, the court says, it's okay. These actions can stand. They send it back down to the Second Circuit, and we're getting there to where we are now. Just a couple more steps in this tortured process. They send it back to the Second Circuit, and the Second Circuit clearly doesn't like this at all. They issue a really sweeping ruling in 2009, and it basically says the entire indecency scheme is vague and unconstitutional, would kick everything out. That goes back to the Supreme Court. And that was argued earlier this year, and that's the ruling we had last week, where oddly enough, the Supreme Court doesn't rule on the bigger issue. They issue an 8-0 ruling. Sotomayor recused herself. And what they said was, we're not even talking about the First Amendment issue. We're talking about a Fifth Amendment due process clause issue that simply said ABC and Fox, at the time of those broadcasts, had no reason to believe they could get in trouble under the due process clause that said something is void for vagueness if a person could not reasonably understand that they would get in trouble. The FCC has acted in these cases in a vague manner. They kick it down to the Second Circuit again now, vacate the decision of the Second Circuit, kick it down for them to take action consistent with this decision. Okay, so that's where we are now. A Fifth Amendment decision in what everybody had thought was a First Amendment case involving potentially putting at risk the entire indecency regulation scheme of the Federal Communications Commission.
And I think, yeah, I mean, like you said, we were all expecting a close decision, one that was going around the First Amendment, and wanted to see this be a very big case, a very big, free speech case. But in the end, it ended up being a unanimous decision. How did that end up happening?
Well, it's interesting because there are a lot of theories. The one I like the best and that I allude to in the blog post I did summarizing this is from Eugene Volokh, the professor at UCLA, who thinks that it was the only way to reach accommodation that would avoid a 4-4 decision. I had predicted, and I sort of toy around with this on our blog under the nickname the Swami, because whenever there's a First Amendment case up at the Supreme Court, I go and I watch. One of the benefits of being in D.C. and a member of the Supreme Court bar is you go and you watch, you get a real good feel, and I always try to predict. And I predicted that the court would overturn these actions, construe things as narrowly as possible, not wanting to upset the Pacifica regulatory scheme that said we need to be able to regulate indecent content on the broadcast airwaves because they are scarce, and specifically from Pacifica, that they're pervasive. Anybody could still just click a radio in drive time or any other time in New York and hear things, that they weren't ready for. I thought it would be a much more fractured decision. And maybe the court recognized that. And they didn't want a 4-4 decision that really did nothing. Maybe they didn't want a fractured decision. I buy into what Volokh's saying is it was the way to get everybody on board with one decision where the court could say something clear. And what they said, unfortunately, wasn't what I don't think either side wanted to hear. The FCC loses on these actions, and the broadcasters might be set up for 4 more years, as I said, of the same thing. We could be back here on Election Day 2016 still with the same issue. We don't know what's coming next.
Yeah, I mean, it's always interesting. I think we've seen this court do this in other areas of law, even when you expect it to revolve around a much bigger issue where they say, well, if we can make this ruling on just this small thing, then we're going to do it. And I think at times you're disappointed that they didn't rule on a larger issue, but at the same time, on the other side of the coin is that they're always making the cases bigger than they want. And that, I think that would be a poor thing. And then finally, what implications does this have going forward for the FCC's indecency policy and then for indecency cases already in the pipeline?
Well, and that's one of the things we're trying to figure out. What's really interesting about the decision is the Supreme Court decision had 18 pages, taking out the syllabus, and a 1-paragraph concurrence from Ginsburg, who actually kind of tried to draw Thomas back into it by saying, I would overturn Pacifica. In fact, I would overturn the entire indecency scheme, the justifications for the scheme. And I know Justice Thomas argued for this in his concurrence in the earlier Fox case, the Administrative Procedure Act case. So that's one thing to keep in the back of your minds as to where this might go next. You now have 2 justices saying, we really want to look at the full constitutional issue. But for now, all we know is, and if you read into those 18 pages, only 5 or 6 of which were actually analysis themselves, and one of those saying, look, we're trying to construe this very, very narrowly. I think if I were an attorney at the FCC, I would be somewhat happy that you could, and say, trying to convince my superiors, we want to construe this narrowly. And from what we're looking at on the side of representing broadcasters, we're a little concerned that this will be construed narrowly. And what that means is this. You have a lot of cases in the pipeline now, and they're not just fines. What we've seen with our broadcast clients is you have applications for renewal, you have transactions pending, and the FCC will not rule on those. They won't pass judgment on those if there's an indecency complaint pending. So it's holding up tons of transactions, tons of applications at the FCC. And I mean, if you read the decision literally, a lot of those still could be held up. This is not the big win broadcasters were looking for. Really, again, the court said, at this time, during these broadcasts, neither Fox nor ABC had sufficient notice to believe that they could be held liable. So when I talked about the 3 points, looking at that middle point from 2002 to 2004, you could argue that everything before the time the FCC in 2004, that the full commission said that Bono's really fucking brilliant statement was for the first time actionable as a fleeting expletive. Everything before that might not have noticed, but anything after 2004, and that's still probably thousands of applications and things in the pipeline, that those might still be arguably indecent under this regulatory scheme. That you can and you might even be able to say, if you're the FCC, that only these very narrow 3 cases that were implicated. You know, throw away the Janet Jackson issue and all that, but only these 3 cases are the ones that have to be looked at, or any of the other, you know, that's still going to pull in all the Fox and ABC affiliates that were in trouble for this, but these are the only people that get relief. So what do I see? I see a lot of haggling over what comes after 2004. I see certainly things that were not involving fleeting expletives giving rise to yet another challenge to the indecency scheme. I think you could look at possibly people still being held hostage by the FCC, as we're saying, for having broadcast a fleeting expletive after 2004. The FCC is saying they presumably should still have been on notice. And then maybe, again, that's where people are challenging this back at the court. Goes all the way up the court system again. We're right back in 4 years.
Mm-hmm. Yeah, it's going to be interesting to watch. I thought this was one we were all waiting to see what First Amendment implications this would have, and it ended up being something different. But still, it's going to be interesting to see what effect it has on broadcasters and the FCC's indecency policy going forward. Well,
exactly.
Once again, that was Kevin Goldberg of Fletcher, and Hildreth and their CommLawBlog. For more on this story, be sure to visit their excellent publications at CommLawBlog.com. And for more LXBN TV interviews, visit us at lxbn.lexblog.com. Thanks, Kevin.
Thank you.